Hi, this is Billy Tarasio, and I am here with CLDP Jen Bone, and we are going to go over what is one of the most important things that you need to know when you file for divorce. Jen, thank you, and let us know what we're going to talk about today.
We are going to talk about the notices that accompany the petition when you file for divorce or establishment. They're slightly different because some items are not necessary within the establishment that they are in dissolution, but we'll just go over the dissolution so it covers all of them.
Fantastic.
Okay, so we will start with the sensitive data sheet. That is the first notice that will be filed. It is a total confidential notice. What does that mean? That means that nobody, not even the party filing it, will ever be able to access it from the clerk of the court. It is going to have your sensitive data, like your dates of birth, your social security numbers, your kids' dates of birth. And so we want to make sure that it's accurate, but we know that it is confidential. However, if you include your address and your address is protected, then we technically don't want to include it on there because that is how the clerk of the court will communicate with you. And then it may make its way to a minute entry with the court. So we still need to protect your address if it is protected. So the first thing that we would do is have you review the sensitive data sheet to make sure we have all of your information correct.
Jen, can I ask a quick question?
Yes.
If the address is protected, what do you do then? Do you just leave it off the sensitive data sheet?
We would leave it off the sensitive data sheet, and then we're going to file a separate motion with the court to let them know that your address is protected.
Awesome. Thank you.
Yes. The next notice is the summons. This is super important because it tells the opposing party, one, a lawsuit's been filed. It's a divorce, but it is still a lawsuit because it's being filed within our superior court system. It also tells him there are 4 superior court locations where he or she can go to file a response. And most importantly, the opposing party will have 20 days from the date of service to be able to file a response if they disagree with you. If you guys agree, a response isn't necessary. However, it's always suggested if you need to preserve your rights. Again, they have 20 days to file a response from the date of service.
Let's just clarify right here. That is the case if you're within the state. But if you're serving someone out of state, they get an additional 10 days, right?
That is correct. Great observation, Billy. Yes, if you are being served out of state, then you will have 30 calendar days to be able to file a response. And that includes even international. So let's say, for example, we get you served in Mexico. You still will have 30 calendar days to be able to file a response.
Okay, and one other question, because calendaring is so dang hard. How does somebody actually figure out what the deadline is?
Great question as well. We will start counting the day after service. So for example, if you were served on February 23rd, you are going to start counting for the calendar days the day after February 24th. From there, we go straight through. Calendar days includes the weekends. If it was business, it would not include the weekends, but this is calendar. So we include all the way through until we get to 20 days. Or
Awesome.
state.
Thank you.
Yes. The next notice is the preliminary injunction. This is super important because it has a lot of what you can do and what you cannot do while the case is pending. I definitely suggest that you read this, and if you have any questions on what you should and should not be doing, you definitely want to consult with your attorney. But the basics: don't hide assets, don't give away assets. If you have a car, don't say, hey, buddy, take my car for $1 because I don't want my spouse to get it. You can't be doing those things. Do not remove the children from the state of Arizona while the case is pending. However, with all of that, if you have mutual agreement, you can do those things. I suggest you get it in writing, but you can do those things if you have mutual agreement.
Okay.
The next notice is if you have minor children, you will have to attend a parent class. So it is the order and notice to attend the parent class. This instructs you as the petitioner, the party filing. You have 45 days from the date that you file to attend the class. The opposing party will have 45 days from the date of service, and that's calendar days from the date of service to complete the class. This is one of those items that, while it's a soft deadline, it has to be done before the judge can enter a final order. First, you got to take the class. It is a really good class. A lot of people will ask, well, are they trying to tell me how to parent? No, they are teaching you how to co-parent now that you're going to have 2 different households. It is a 4-hour class. It's $50. It's one of those classes, though, where you don't have to do all 4 hours at once. You can do 10 minutes here, 5 minutes here, 20 minutes there. You do not have to take all 4 hours at once. I highly suggest that once you take the class, that you send me the certificate. Every once in a while, the provider does not get it online with the court. And so we'll just monitor that for you. And if we need to do a notice of filing, then we will. There are 3 classes that you can take. I will also send you a link after the date of service, but they are here within the order. And you can register as long as we have a case number. Go ahead and start registering for that class.
Nice. Okay.
The next notice is the notice to convert health insurance. If you are maintaining insurance on your spouse or your children, or if your spouse is maintaining it on you or your children, this says while the case is pending, you cannot remove somebody from insurance. It doesn't even matter if open enrollment happens. Do not remove somebody from health insurance while the case is pending. This is similar to the preliminary injunction, but specific to health insurance. If, let's say, your spouse went to his employer and said, you know what, I want to remove my wife right now. Nope, going to tell them to go pound sand. Even the employers know that they should not be doing this. Somebody will be held in contempt of court if they do. So rest assured, while the case is pending, if you need insurance because it's carried by your spouse, you will have insurance until a final entry of the decree.
Okay, Jen, before you continue, I want to address one thing that you said that is so important. If you violate these orders, they are court orders. So if you violate them, you are at risk of being held in contempt. Contempt means you have made a willful, intentional violation of a court order. So these are not optional. These are actual orders that apply to you the moment someone files a petition for divorce. So thank you so much for saying that.
Yes, you are 100% correct, Billy. The last notice is called the notice regarding creditors. What this is letting you know is that, look, while a creditor while you may have joint debt with a creditor, the judge cannot tell a creditor what to do. A creditor is a third party. The judge can only tell the petitioner and the respondent what to do. If you guys have joint debt and you divide it somehow in your decree, the creditor doesn't care. If you both sign to it, they're going to come after both of you. You would then have to file an enforcement action against the other party if it was divided individually. And so just know that a judge can never tell a third party, meaning a creditor, what to do. A judge can only tell the petitioner and respondent what to do. So those are all of the notices. Any questions on the notices, or do you need me to clarify anything?
Yes, I do. I want you to clarify the notice regarding creditors. So this can be used to go to specific creditors?
Yes, that is also an option, and good question, because I didn't clarify that. You can also there's another form that we can provide that will list out where you can indicate who the creditor is so you can get information regarding that debt. Just in case you're unsure, is that a joint debt? Is it an individual debt? Because as you progress through your case, you have a right to know those because those have to be resolved somehow.
This is a super powerful document that is not used enough in family court, either by lawyers or by people who are representing themselves. This notice, this court order, can help you gather information from third parties and perhaps avoid a subpoena. Now, does it really work? Have you tried it? Does it work?
It does. Most of them will say, hey, we want a subpoena because they don't want to give any information. It's not that HIPAA applies like it does with insurance and health records, things like that. But creditors are still always leery about giving information that they shouldn't. But they will let you know, they will write you back, and it's typically in writing. It's not by email, and they will let you know if they're going to provide it or not. Mm-hmm. Not go consult with your attorney and figure out a different way, because there are other methods to still get that information.
Awesome. Thank you.
Yes, you are so welcome.
Anything else we have to cover today, or is that it?
That's it. Look at that. It took 10 minutes to go over that stuff.
Wow, Jen, you are so impressive. And I think this information is so valuable. Thank you so much for your time today and for doing that.
You're so welcome. You have a wonderful day.